Bob Wallace is very precise, and he started this at 2 o'clock, so we have to start more or less on time. Good afternoon. Welcome to the ABI Bankruptcy Commission. I'm Liz Paris. I'm from Portland, Oregon. I'm a retired bankruptcy judge, and I am one of the two co-chairs, along with Bill Brown, to my right.
And I'm a retired judge from the Western District of Tennessee.
And to save time, our bios, I think, are in the materials. Bob Wallace makes the trains run on time, and he's more concerned with making the trains run on time than with all the introductions. So with that, we're going to start the testimony. We've organized you into panels. We're going to let you deliver your statements all the way through for your whole panel, and then the commissioners will ask their questions. We find that's more productive. So with that, we'll start with Judge Isikoff.
Thank you. Thank you. I'm Laurel Isikoff. I'm the Chief Bankruptcy Judge for the Southern District of Florida. I thank you all for the opportunity to appear today. I will be presenting summary comments, and I'll provide a more detailed written testimony within the next 2 weeks. I'll be speaking today about surrender in real property and the impact of modification and defaults with reaffirmation. The first topic is what are the consequences of surrender of real property in bankruptcy and what problems we can fix. Is a debtor required to retain and reaffirm or surrender real property in a Chapter 7 case? Should there be or is there a ride-through option for real property? Is a debtor in a Chapter 13 case required to either pay the secured claim or surrender the property? Chapter 13 requires that a debtor, with respect to a secured claim, either surrender the collateral to the secured creditor or pay the secured creditor on account of that claim. But many courts allow debtors to treat outside the plan, where debtors continue to fight foreclosure actions or seek to modify loans. But treat outside the plan does not exist in the Bankruptcy Code. What does surrender mean? While the law is fairly consistent that a debtor is not required to deliver the collateral to the secured creditor as opposed to making the collateral available to the secured creditor, the law is also clear, assuming no state law to the contrary, that the secured creditor is not required to accept the collateral. But should the secured creditor be required to accept the collateral? To whom is surrender made in a Chapter 7 case regarding real property? Is it the trustee? Is it the secured creditor? If the trustee does not administer the surrendered real property, does the surrender automatically go to the secured creditor? What are the consequences of surrender? Can the debtor defend a foreclosure case if the debtor has elected to surrender? And how long can that creditor wait to complain? Can the debtor lose his or her discharge if the debtor defends a foreclosure action after indicating an intent to surrender? I would ask the Commission to consider proposing changes to the Bankruptcy Code to address some of these issues, which would create more certainty for both debtors and secured creditors. While I do not believe the Code is ambiguous, Section 521 can be modified to make clear, as was done in the case of personal property, whether a Chapter 7 debtor is surrendered to a Chapter 7 trustee of real property, which property the Chapter 7 trustee does not administer, would automatically convert that surrender to the benefit of the creditor who held the lien. The Commission should also consider requesting the Rules Committee consider a rule requiring a secured creditor with respect to real property to file a motion in the bankruptcy court before a bankruptcy case is closed, compelling a debtor to perform his or her statement of intention in Chapter 7 or performing the obligations related to surrender and the other applicable provisions of the Bankruptcy Code. A secured creditor's failure to do so should be a waiver of the secured creditor's right to rely on the debtor's surrender in any non-bankruptcy proceeding. I believe the Bankruptcy Code should also be modified to make provisions for what is expected or required of a secured creditor to whom real property has been surrendered. We have read too many cases about debtors who surrender their real property and move out of the premises, but which real property the secured creditor refuses to take title to, leading to failure to secure, diminishing the value of the collateral, failing to maintain, causing municipal or HOA liens to accrue, dangerous conditions, children dying in unfenced pools, uninsured loss, all of which for which the debtor can still be liable. I would ask the Commission to consider recommending changes to the bankruptcy code that would either require a secured creditor to accept title if tendered by a debtor, or at least making the tender of title more attractive option for secured creditors. For example, if a debtor offered a deed in lieu or similar arrangement subject to non-merger to eliminate subordinate liens, the lender would be required to accept with the understanding that the debtor would have to vacate the property, if not already vacated, within a certain period of time, at which time title would actually transfer, or if the debtor wished to remain on the property after the transfer of title, the debtor would have to pay some kind of rent to the secured creditor. Or, if the secured creditor declined to accept the tender and the debtor did not vacate the property, the secured creditor would not have the right to seek interest or costs, including attorney's fees, from the date the tender would have been effective. The debtor would be required to maintain the property while the debtor was occupying the premises. If the debtor was earning income from the property, the net income would have to be tendered to the lender, which funds would have to be applied to any principal balance due on the loan. If the secured creditor declined to accept the tender and the debtor did vacate the property and advised the secured creditor in writing of the date of vacancy, the lender would indemnify the debtor for any loss caused by any failure to maintain the premises after vacancy. The Commission should consider whether treat outside the plan, or in Chapter 7, a ride-through, is something that should be codified so that there's a uniform understanding of whether a debtor has the option with respect to real property to retain but not reaffirm, and what the consequences of that decision would be. And finally, I believe the Code should make clear that Section 105 cannot be used to revoke a debtor's discharge where a debtor has continued to fight a foreclosure action after indicating that the debtor intends to surrender the property that is the subject of the foreclosure action. I'll now turn to my second topic, discharge and reaffirmation. For debtors who have not reaffirmed debts, the mortgage holders are not reporting the mortgage payments to the credit reporting agencies, and the mortgage holder will not agree to modify the loan without reaffirmation. In fact, the mortgage holders are requiring as a condition of modification that the debtor get the discharge revoked and the reaffirmation approved. With respect to credit reporting, under 15 U.S.C. Section 168(1), a creditor has a duty to provide to consumer reporting agencies any corrections or additional information that is necessary to make the information provided to the agency complete and accurate. The applicable Code of Federal Regulations states, quote, "A consumer reporting agency may include delinquencies on debts discharged in bankruptcy in consumer reports, but must accurately note the status of the debt, e.g. discharged, voluntarily repaid," end quote. In other words, a discharged debt may still be shown on the credit report, but the status of the debt must also be included. So if the debtor does make voluntary payments, those are supposed to be reported. Creditors take the position that this reporting obligation on the Code of Federal Regulations is on the consumer reporting agency, but not on them. With respect to modification, secured creditors take the position that negotiating to modify a loan that has been discharged is a violation of the discharge injunction, and there are some courts that in fact have held that. Some courts have allowed vacating the discharge to file these agreements as a quote-unquote victimless act, but that is not the case. First of all, there's no such relief that exists under the Code, and second, there is a victim. I had one debtor that came to me devastated because she'd worked so hard to reestablish her credit after her bankruptcy discharge. Her discharge was vacated to file the reaffirmation agreement, so it showed up as a second discharge, and her credit rating went all the way back down to where it was after the first bankruptcy. After that, I refused to do this anymore. I think these are easy fixes. With respect to credit reporting, I believe the Bankruptcy Code and the applicable non-bankruptcy statutes and regulations should be changed to clearly state that secured creditors are required to report payments made on account of debts discharged in bankruptcy. With respect to modifications, the Bankruptcy Code discharge provisions can be changed to make clear that a loan that continues to be secured by real property of the debtor can be modified without violating the discharge injunction. Again, I want to thank the Commission for this opportunity. As I noted, I will submit more detailed comments with footnotes in writing. Thank you.
Thank you. The next panelist, Mr. Butler.
Chairperson Brown and Paris, Commissioners, good afternoon. My name is Jack Butler. I'm grateful to have had the opportunity to submit a written statement to the Commission and to appear before you today at this public meeting. My remarks today will focus on steps that the Commission can take to help break down traditional access barriers to the judicial system experienced by unsophisticated consumers, especially those who live outside of urban areas. My testimony is really offered from three vantage points. First, as a former practicing attorney for whom access to justice is a longstanding personal passion and commitment. Second, as the Chief Executive Officer of Merchant Bank Birchlake Holdings, that is an investor in the legal tech industry. And third, finally, as a commissioner on ABI's Business Bankruptcy Commission that completed its work and published its report a few years ago in December of 2014. Today, with my law career in the rearview mirror, I'm completely focused and invested on synergistic and proprietary approaches to the investment of both intellectual and financial capital in complex and stressed businesses. Relevant to the Commission's deliberations is our experience in advising and investing in the legal tech industry. Earlier this year, we invested in Justiva LLC, which does business as Bridge Legal, a legal tech company that provides various business process and marketing services and strategies to consumer law firms. Our investment thesis is centered upon our view that technology increasingly is a game changer in the delivery of consumer legal services and will help address the need for affordable and practical access to legal justice by consumers. It's our clear conviction that legal tech, including artificial intelligence, will continue to break down barriers to access to consumers across a broad spectrum of legal needs, including in the consumer bankruptcy area. The reality facing every business and profession is that technology is transforming how we live our lives. In addition to the personal empowerment, convenience, and peace of mind that consumers feel from controlling their world from their tablets, smartphones, and wearables, the way in which information and services are delivered to consumers has irrevocably changed over the last 2 decades. Just in the 4 days prior to this afternoon's hearing of the Commission, consumers participated in 2 widely adopted online events that illustrate how profoundly technology has affected consumer behavior, Cyber Monday and #Giving Tuesday. On Cyber Monday of this week, digital transactions reached a record $6.59 billion, marking a 17% increase from a year ago and makes Monday the largest online shopping day in American history. Last year, #Giving Tuesday, a global day of giving, hauled in almost $170 million worldwide. This fundamental change in consumer behavior is affecting every industry and profession. In the legal profession, there's an evolving value proposition for both clients and lawyers. Business and consumer clients are demanding simpler, faster, more convenient, more accountable, more responsive, and less expensive access to lawyers and legal solutions. Lawyers are responding to these client pressures, thinking about how their bricks-and-mortar, leveraged, hourly rate-based, paper-driven business model can adapt to become more attractive to clients while both maximizing profits and improving work-life balance for both law firm partners and their millennial associates, paralegals, and staff. Although technology is driving innovation in the United States legal system, there continues to be an unacceptable systemic limitation on access to justice by those Americans who arguably require access most of all. These systemic barriers are accentuated outside of large urban centers. Nearly 20% of Americans live in rural areas, but less than 2% of small law practices are in those areas. Those still practicing law in small towns are often nearing retirement age without anyone to take over their practices. And without an attorney nearby, rural residents can drive 100 miles or more to take care of routine matters like child custody, estate planning, taxes, and more. For people of limited means, a long drive is a logistical hardship. It requires gas, a day away from work if they're lucky to be employed, and sometimes an overnight stay. Census information shows that rural communities are disproportionately poor. All this creates a justice gap, with legal needs going unmet because potential clients can't find a lawyer or they can't afford the lawyers they find. Legal tech companies like Bridge Legal are developing sophisticated AI-enhanced legal tools that can be used by statewide, regional, and national bricks-and-mortar law firms to eliminate barriers to access faced by rural consumers as well as by consumers wherever they reside, who either do not know how to access the system or are unwilling to do so without the comfort of using their tablet or smartphone to educate themselves. Ironically, while critics of legal services delivery through technology-enhanced applications and the Internet often characterize the activity as the unethical solicitation of clients, it is the consumer, himself or herself, that initiates an inquiry and reaches out for help. Without these local, regional, national law firms adapting the latest technology and channels of client communications, existing barriers to access to justice will remain, and consumers' needs will remain unmet. I believe the most important issue for this Commission to consider in its work is access to justice, which both transcends and informs almost every topic the Commission's identified for study and consideration. Local consumer bankruptcy law firms play an important role in the consumer system, but they alone have not and will not solve the justice gap that plagues middle-class and lower-income consumers. So what can the Commission do to help eliminate the justice gap? First, we need to acknowledge and prioritize the problem. The Commission's final report should examine the justice gap and make access to justice a prism through which its other recommendations are viewed and presented. Artificial barriers to justice must be eliminated. Let's also consider the fact that consumers' major creditors already benefit from scaled efficiencies in their participation in consumer bankruptcy cases. We need to even the playing field in consumer bankruptcy to foster an intelligent fabric of multi-state, regional, local firms to serve consumers. These firms have to be connected and coordinated with their clients through sophisticated technology that increases efficiencies, reduces clerical errors, and creates viable, long-term, profitable debtor law firms. Second, consumer bankruptcy law firms need to play by the same rules. The Constitution and the Bankruptcy Code contemplate a uniform bankruptcy system across all federal jurisdictions. The Commission should recommend that the Bankruptcy Rules Committee examine local rules nationwide to determine which rules and procedures represent best practices. In addition, Rule 4002B should be revisited and revised to promote uniformity of practice. We need to move away from a system where document production by debtors to trustees varies by different trustees within the same district and across districts. Third, the Commission should consider recommendations to embrace the technology world in which consumers live today. Some rule changes, such as explicitly clarifying that electronic signatures and records from debtors are authorized, are long overdue. Other rule changes, such as expressly authorizing the use of remote video access for Section 341 creditors' meetings and for court hearings, should be authorized promptly, but with a delayed effective date, to facilitate preparation and transition, including thoughtful input from the Executive Office of the United States Trustee and local bankruptcy courts and bar organizations. In closing, I'd like to offer some personal reflections about the work of this Commission. For me, my service as a Commissioner on the ABI Commission to study the reform of Chapter 11 is one of the most meaningful things I've done in my legal and business careers. What made that experience so rewarding was not only the intellectual interactions with so many talented people, but the written report that we produced. In my written statement to this Commission, I shared some premises that our Commissioners agreed to, which allowed us to write a consensual report without any written dissents. For today's public meeting, I'll simply close by saying that I have enormous respect for the task that you've signed up for and how you're carrying out your mandate. Please accept my best wishes for the successful completion of the Commission's work, my admiration and thanks for your personal service, and my appreciation for the opportunity to present these observations and suggestions for your consideration.
Thank you. Judge Barish,
And
followed by Judge Clarkson.
Yeah, thank you. My name is Marty Barish. I'm a bankruptcy judge in the Central District of California. I'm sharing my time today with my colleague, Judge Scott Clarkson, also of the same court. We want to mention at the outset that these are our opinions and not necessarily those of our colleagues or our court. Today we want to talk about, the problem that we want to talk about is that there are really too many individual Chapter 11 cases being filed, which cases would be better served in Chapter 13. And this is because, in our view, the Chapter 13 debt limitations of the debt limitations in Section 109E. Those limits render Chapter 13 available only to a debtor with less than just under $395,000 in non-contingent liquidated unsecured debts and somewhere less than $1.2 million in non-contingent liquidated secured debts. This creates a problem that is particularly acute in our district, where the economy is heavily driven by real estate in Southern California, particularly residential real estate. It's not uncommon for individuals who make a decent living and live a reasonably modest lifestyle to invest their disposable income in real estate, where there are low barriers to entry and where residential mortgage financing is readily available with only a modest equity investment. It is a form, if you will, of small business that is very common in our district. When there's a hiccup or a crash in the residential real estate market, these individuals seek often bankruptcy relief, and they're entitled to bankruptcy relief. But because of the limits in Section 109E, they're forced to file individual Chapter 11 cases rather than Chapter 13 cases. But we would argue that Chapter 11 is not always well suited for these cases, and that many of these debtors would be better off and their cases more effectively and less expensively dealt with in a Chapter 13. As a result of this phenomenon, the cost of reorganization under Chapter 11 for the individual that has property that exceeds the debt limits, the cost is higher, the time to reorganize is longer. These cases very often are initiated by consumer lawyers who have a great deal of experience in Chapter 13 cases, but very limited experience in Chapter 11. And the interests of unsecured creditors often are inadequately served because in individual Chapter 11 cases in the real world, number one, committees are rarely appointed, and the amount at issue doesn't justify it. Second, there's no trustee, as there is in Chapter 13, to vet the plan and the debtor's ability to perform the plan. And as a court, and they're better equipped than a court is to perform that function. And third, unsecured creditors individually typically don't have the wherewithal to assess or litigate whether an individual Chapter 11 debtor is providing the debtor's net disposable income to unsecured creditors under the plan. The Chapter 13 trustee, who is expert in that work and doing that work efficiently, is better positioned to do that. So what is the stated policy behind the debt limit in the first place? When we go back to the legislative history, we see things such as the Congress intending Chapter 13 relief to go beyond wage earners, as it was previously thought of, to self-employed individuals and sole proprietors, sometimes referred to in the legislative history as mom and pop businesses, who were previously limited to very cumbersome Chapter 11, Chapter XI, to reorganize. And in 1994, the legislative history to those revisions suggests that another purpose was to help encourage individual debtors to elect Chapter 13 repayment rather than liquidation. The cases that have touched on this articulate a desire to protect unsecured creditors, that somehow Chapter 11 is better for unsecured creditors, but I think these concerns are overly stated. We rarely see in Chapter 11 individual cases committees, and we see debtors, even though there's voting, which you don't have in Chapter 13, you see debtors struggle to get even a single creditor in a class to return a ballot. We would propose that the Commission recommend the elimination of the Chapter 13 debt limits under 109E, or at least eliminate the limit on secured debt. I'm going to hand the floor over to my colleague.
Good afternoon. I'm Scott Clarkson. I'm a judge from the Central District of California sitting in Santa Ana. I'll be very brief. First of all, I'd like to associate myself with all of the remarks that have been said today by the panel. On January 3, 1977, I was sitting at my brand new desk when two gentlemen walked into my office in the Longworth House office building, Richard Levin and Ken Klee. They said, "What do you know about bankruptcy?" I said, "Absolutely nothing, and I hope never to." And they said, "You're our guy." 1 week later, they took me into a conference room where I met a gentleman by the name of Conrad Sear and a gentleman by the name of Joe Lee. And they sat there, and they said, "First of all, you don't look like you know anything about bankruptcy." And I said, "You're absolutely right." "Well, let me tell you." And for the next 2 years, Joe Lee and Conrad Sear and Larry Tribe and Lawrence King and a host of judges from all over the country and scholars from all over the country came down and talked to us on the House side and on the Senate side later and told us the thing that we have to remember, and this is why I'm here today, just to remind you, we have to eliminate the barriers of entry into the opportunities of fresh starts for our citizens. We have to make sure that the system is designed and will continue to be designed so that the people that need a fresh start and creditors who need equal and fair treatment get a fair shake under our legislative systems. We passed the 1978 Act, and we had a great start. In the House bill, I don't know if anyone remembers this, but Chapter 13 was almost never there because of that debt limit problem. I stayed in Washington for another 7 years, and I watched the continuing diminution of the lack of barriers, the 84 amendments, and all through until the 2005 Act, which was previously vetoed by President William Clinton, in 1998. And I saw that the barriers that we had and that we tried to keep from occurring, and Joe Lee and Conrad Sear said should never happen again, we're back. Means testing, certificates of completion for credit counseling that are expensive. People can't afford this. I'm just here to remind you that the barriers, including a lack of increase of the debt ceilings for Chapter 13s, are hitting hundreds of thousands of people throughout our country on a daily basis. And the Commission's mission should be to remind themselves that legislative and judicial activities in the field of everything you're considering should be promoted under the wisdom of Conrad Sear and Joe Lee. And that is, let's get an opportunity for people to have a fresh start. Let's get it back into the proper mindset that we started off in 1978. Thank you very much.
Thank you. We now have time for a few questions from commissioners.
Let me start, judges. You're talking about the debt limit, and you mentioned some alternatives. What do you see as the preferential way, to eliminate the debt limit completely, or?
Yeah, my preferred outcome would be to eliminate the debt limit altogether. I think there's a tendency when we look at law revision to take what's there as gospel, but I think you have the opportunity as commissioners to go back and question first principles and ask yourself, well, what purpose does it really serve? And is it a necessary component of the code and a necessary barrier? And we would argue that it isn't. And in fact, individual Chapter 11s in so many ways have, over the years, because of the other various revisions, substantively have become very similar in the outcome. So it just makes it more expensive and less likely that people will get relief.
Judge Isikoff, you raised the issue of debtor payments not being either appropriately or all reflected on the credit reports. Should we be recommending a change to the bankruptcy code, or would it be equally effective to recommend changes to the Fair Credit Reporting Act and how it's enforced?
I think probably the recommendations would be to the Fair Credit Reporting Act, although, again, it seems nonsensical to me that the creditors are taking the position that it's not their obligation under the CFRs to report the voluntary payments, and that somehow the credit agencies are supposed to sua sponte know that this is happening. But be that as it may, in order to clarify what the creditors are saying apparently is an ambiguity, that would be the appropriate place to start. Now, if the commission thought it was appropriate, you might also consider whether the discharge provisions should be reviewed with respect to the failure to report the voluntary payments as a way of trying to coerce reaffirmation in order to get those payments reported, which is exactly what they do when they get to the modification stage.
Judge Isikoff, number one, thank you to the panel for coming in and testifying today. Implicit within part of your proposal regarding surrender are implications regarding Butner and sovereign immunity rights. I mean, some of this is governed by state court law. Is your paper going, state laws, is your paper going to address those issues in addition to the bankruptcy code provision changes that are necessary to accomplish what you're proposing?
Well, I looked at this very carefully and considered it. If you look at, there are a lot of places in the bankruptcy code where state law is overridden. And in considering and I will explain this further as I look at more states, but the issue of requiring surrender to me is no more constitutionally impaired than the ability to strip down and strip off loans These all impact secured creditors' rights. And all I'm suggesting is that in looking at, again, as my colleagues mentioned, the purpose of the bankruptcy code, which is to protect rights but also to protect a fresh start, when we have this situation where Chapter 7 debtors especially do not realize that they surrender their home, they vacate the premises, and then all of a sudden a child falls into an unfenced pool that hasn't been cleaned in 2 years, and they are liable on that debt, in addition to being horrified about the loss, that something needs to be done. So I think that you will see in my more detailed report that I do not believe, based on the examples I cite of other provisions in the bankruptcy code, that there's any sovereign immunity problems.
And you indicated that it could be done by rule. You thought that a rule could be enacted, I think I wrote to, when collateral is surrendered in a plan, a confirmed plan, that it become, that this rule would require acceptance.
No, and I apologize if I wasn't clear, that because I recognize there's only a limit to what a rule can do. Is what has happened, at least in the cases before that I have seen in my district that I examined very closely when I worked on my El Kubi opinion, is that lenders come in 3 and 4 years after the fact to bankruptcy court seeking to get the bankruptcy court to direct the debtor to comply with the surrender. And I think that it would be appropriate to require by rule, if a lender is going to rely on the debtor's failure to perform a statement of intention, they have plenty of time when the case, before the case is closed, whether it's a Chapter 7 or a Chapter 13, especially a Chapter 13, if the debtor is not complying with the statement of intention, well, in Chapter 7 with the statement of intention, in the Chapter 13 with the plan that says surrender, that the lender is required to come into the bankruptcy court before the bankruptcy case is closed and seek relief there. If not, the only right that's compromised with respect to the secured creditor is that they can't come back to bankruptcy court or argue in a state court proceeding, well, the debtor said they were going to surrender and they're fighting my foreclosure action. So it's just a timing thing. If it really is bothering you, lender, then tell the bankruptcy court about it while the bankruptcy case is open. Otherwise, you can't raise that argument after the fact. That was the rule part that I was focusing on.
We're probably out of time because we want to allow some time for the next panel, but I thank you for your comments, and we'll look forward to getting written.
Thank you very much.
Thank you.
Cut you off.
Well, I wanted to ask, Paresh, if there was a deadline, if it's too low, what is it? Don't let the perfect get in the way. Let the perfect get in the way of the good. What would you propose as a deadline? I don't care about either. That would work.
Secured or unsecured deficiency, don't count.
All right, my cheat sheet here says that Mr. Rivera comes next.
Okay.
Congratulations for your honor today.
Thank you very much. All right, I apologize. Technology's great when it works.
See, it's those under 40 that use the technology. I don't see any, but I see one, she was a 40 under 42.
So I want to thank the Commission for the opportunity to be here today. I especially want to thank Judge Weedoff, who I understand had to be called back to Chicago, and Professor Lawless for offering me the opportunity to share my thoughts with you today. I hope that you will forgive me for the disjointed nature of my remarks. Until Tuesday evening, I had planned to spend the afternoon playing hooky on one of the golf courses. It was then that my assistant took a call from Gene at the ABI. Not knowing who would be on the other line, I took the call, and lo and behold, it was Judge Weedoff who invited me to present to the Commission today. As I'm sure was expected of me, and frankly, who says no to the president of the ABI, I graciously accepted. But that's when the panic set in. The Commission meeting, this meeting was only 2 days away, 3 days away, and to be frank, I'd never had the occasion to stop and think about how we might improve our bankruptcy system. To be honest, no one had ever asked. I have waited for the call from my congressman, and it has not come. But I rallied, I put pen to paper, and here I am. A little bit about me so that you can understand my remarks. Since 2005, I've represented lenders, landlords, individuals, and financial institutions in both consumer and business cases. I'm board certified in both business and consumer bankruptcy, and I serve on the board of directors of the American Board of Certification. Since 2010, I have served on the panel of trustees for the Middle District of Florida. And as Commissioner Dunn pointed out, I'm proud to share that earlier today I was recognized as one of ABI's 40 under 40. With this background in mind, and now that someone has asked my opinion, I believe there are a number of areas of reform that would be beneficial. Personally, I'm going to talk about two sorts of concepts. One are what I consider to be almost systematic or access to justice, at least in my opinion. And then the other item is I also share in the prior panelists' opinion that the Section 109E limits should either be abolished or significantly increased. First, to access to what I consider to be almost access to justice issues, the number of authorized judges, I think we need more, and the compensation of Chapter 7 trustees in no asset cases, I believe they must be increased, are two areas where reform is necessary. While I appreciate that both the courts around the country and the trustees are able to do more with less due to advances in technology, neither the number of bankruptcy judgeships nor the compensation of Chapter 7 trustees has increased much since the early 1990s. For instance, the number of bankruptcy judges authorized in the Middle District of Florida has not increased in 25 years, well, until last month, during which time bankruptcy filings and judicial caseload have steadily increased. The current allotment of bankruptcy judges authorized in the Middle District dates to the Bankruptcy Judgeship Act of 1992, which increased the number of authorized judges from 4 to 8. In 1991, approximately 30,500 cases were filed in the Middle District. Since then, the number of cases filed has increased to 41,000 in 2000, 51,736 in 2005, and an all-time high of 66,618 cases in 2010. If my math is correct, that's a 220% increase. Now, obviously, the caseload has dropped, but again, it's a 250% increase in caseload since those authorized judges in 1992 took their seats. Now, the situation in the Middle District of Florida has improved. Congress has recently authorized a new temporary judgeship for the district, and although it will not be filled immediately, when the need arises, we will have another judge available. However, a failure to authorize additional judgeships in other districts could arguably lead to delays in the efficient administration of cases in the future. While our bankruptcy courts have made do and can likely perform critical functions with present judge allocations, if case filings increase as expected, or at least as I expect, the court's ability to timely and efficiently conduct hearings might be at risk. For instance, emergency hearings may become problematic to schedule, and a general slowdown could be felt. Certainly, we felt it in our district after the Great Recession, where I practiced. Fort Myers was commonly known as the ground zero of the foreclosure crisis. Compliance with statutory deadlines may become threatened. The efficient resolution of issues, which is critical to reorganizations and allows a fresh start in claims distributions, is at risk without sufficient judges. Likewise, the failure to increase Chapter 7 trustee compensation could also lead to the delays in the efficient administration of cases in the future. While there are many areas for disagreement on the issue of a potential increase in trustee compensation, for instance, how should it be accomplished, who should pay for it, we can all likely agree that the availability of talented trustees willing to serve is necessary for the administration of Chapter 7 cases. I think we also can all likely agree that a fee system that was last revisited in 1994 and has not increased since that time should at a minimum be reexamined. Otherwise, we run the risk of losing experienced trustees to resignation without the means to attract new, well-qualified candidates. Finally, I'd suggest the Commission recommend Congress repeal the requirement, Most importantly, I suggest the Commission recommend Congress significantly increase or altogether repeal the debt limits for Chapter 13 debtors codified at Section 109E of the Code. While I have not had an opportunity to independently research the legislative history of the debt limits, I understand from the comments of the prior panelists as well as the written submissions of others that the drafters of the code intended to limit Chapter 13 to mom-and-pop small businesses and funnel more complex businesses cases to Chapter 11. However, I think most consumer practitioners will agree that the current debt limits are out of touch with our current national economy and in any event have long ago ceased to accomplish their stated objective. I believe the current debt limits are artificial limits that serve little to no purpose. Chapter 13 should be a simpler alternative to Chapter 11 for individuals with regular income. There's no need for a debt limitation. In considering an increase or repeal of the debt limits in Chapter 13, I am particularly concerned about how the increased cost of higher education could impact the availability of relief under Chapter 13. I'm the father of 4 sons. My oldest son is 17 years old and beginning to seriously look at colleges. He's an excellent student and a great test taker. He hopes to enroll at Georgia Tech in the fall of 2019 and study to become an engineer. Presumably, he will need some form of postgraduate study to achieve his goal. Given his goals, it's not inconceivable that he might incur unsecured student loan obligations well in excess of the current limits of approximately $395,000. While I hope my son will never have a need to seek bankruptcy relief, we all know that bad things happen to good people. Under these circumstances, if something bad was to happen to him and he was to have a need to seek relief, Chapter 13 would likely not be available to him. What more if he was fortunate enough to be successful and come out of school with a good-paying job at the same time that the bad things happened to him? His only option for relief might be Chapter 11. Under the current scheme, my best hope is that I did not guarantee his student loans. I've heard the bell. I think that's my time. Thank you.
Judge Deal.
Okay. Thank you. Thank you for letting me be here. Thank Gene Wiedoff for twisting my arm for the second time. I gave some testimony before a subgroup of the commission at the NCBJ, and I focused there on student loan issues, and I'd refer you to my prior testimony on that. And like that prior testimony, I'd like to give a caveat. You know, I'm not an academic. I don't perform empirical studies. All I can tell you is that I've sat on a very busy consumer bankruptcy court for the last 14 years, so I've seen a lot of cases. And so my thoughts really come from an anecdotal, what I've observed more than anything else. But in thinking about a theme today, and I came in the middle of the last one, I thought about several things in the bankruptcy code that I think really increase the expense to debtors of getting that fresh start without really serving any legitimate purpose for any other reason. And so that's what I would like to focus on today. The first of those is the requirement for a pre-petition credit briefing as an entry requirement for a consumer bankruptcy filing. I think really this is a bad thing for 4 separate reasons. One, I think to the extent that the purpose of this was to divert people into a non-bankruptcy remedy, of course, I have not seen in any of the cases where the credit briefing ever resulted in a certificate that said, you don't need bankruptcy, go seek some other relief. Now, of course, you could argue that I would never see those because those people wouldn't be filing bankruptcy, but common sense tells me that these people who come to a lawyer on the eve of foreclosure, on the eve of repossession of their car, are told, go sit down at the computer and do this, and we generate a certificate. I really don't think it's of any benefit to anybody. Second of all, I think it is a waste of judicial resources. If I had had time, I would have counted the hundreds, maybe thousands of bankruptcy court opinions that talk about dismissing cases for cause because they didn't obtain the credit counseling certificate. I mean, people have written numerous opinions about this. Whether or not getting your counseling on the day you file is within the 180 days, what are bankruptcy judges judges doing, having to spend their time thinking about that kind of issue? How does that help anybody's fresh start? Cases filed without that certificate, are they cases or not? Was there a stay or wasn't a stay? Again, I don't really think that that assists the goals of the consumer bankruptcy system. Third, I think it is a real trap for pro se filers. The cases that I see in my court where the issue is actually raised, 99 out of 100 are a pro se debtor that had no idea they needed this certificate, but they come to court, and some of them, they're in very good faith, and they're struggling to get it done right, and they get kicked out and have to start over again with the consequences of a second case. And finally, I think Chapter 7 trustees are disserved by this, because obviously the question for the Chapter 7 trustee is, are there assets to administer? And the ability of another creditor or even the debtor themselves to raise the issue of, well, I didn't have the credit certificate, so I'm not really eligible to be here, just causes a problem for Chapter 7 trustees. And that's without regard to the actual cost of it, which, you know, has come down since the 2005 Act was filed. I mean, it used to be a $50 tax. Now I think it's a $17 tax. But in any event, I don't really think it serves a purpose. Secondly, the post-petition counseling certificate, I think maybe has a little bit more utility, but where I think the problem becomes is in a Chapter 13 case. It really frustrates me that you have a debtor that has been living on this budget for 3 to 5 years, and then you say they need a course to tell them how to spend their money when you have basically supervised it for this length of time. And then to add insult to injury, they go through all this and they don't get their discharge because they haven't filed this form. They probably aren't keeping up with their lawyer as much as you would think they would. So you're really penalizing somebody who has, in good faith, used their efforts to pay a substantial portion or some portion of their debt, all their secured debt. And I really don't think that's a good thing. The final thing I want to touch on is Section 362C3, which talks about the scope and duration of the stay in a second case within the year. There's no question in my mind that that needs to be clarified. It's sort of less important to me what it's clarified to say. As you all know, that section says the stay under subsection A with respect to any action taken with respect to a debt or property securing such debt or with respect to any release shall terminate with respect to the debtor on the 30th day after the filing of the case. Now, obviously, there are several different trends in cases as to whether or not this applies only to property of the debtor or also to property of the estate, whether the stay terminates totally or only as to certain things. I think it makes for a situation where a lot of people have to spend extra money at the beginning of a case trying to protect themselves. The debtors feel a need to file a motion to extend the stay, even though from my observations in the court, 95% of them are unopposed by any of the creditors, but they had to pay more to their lawyer because it involves a second case and an imposition of the stay. The creditors file motions for relief from stay anyway because they're unsure of what exactly has happened. So from a system standpoint, I just think saying what it means and what it doesn't mean would, again, save a lot of judicial resources as people try to parse through this legislation. Personally, I would say that I would favor no real difference in the stay on a second case. Again, my experience says that for a lot of debtors, it takes a second try to get it right. They come to realize they need to surrender something, they don't understand the system, and it's not a good faith, bad faith thing. They're trying to do the right thing, they just can't get there the first time. And so I think there really shouldn't be a ramification, but as I said, that's less important to me than everybody knowing what there is. In our district, we don't have a no-look fee, but we do let people sort of charge the market. And the market, I'd say prior to today, was about $4,500 for a Chapter 13 case, probably $2,000, $2,250 for a Chapter 7. We expect with the new plan that that's going to be up closer to $5,000 for a Chapter 13. That's pretty expensive. And I think that the Commission ought to focus on ways where we have less technical requirements and more, let's get to the heart of the matter. Thank you.
Thank you. My reporter tells me we're actually at our time, but I suspect the panel has a few questions. So we will probably go over a few minutes if you
Okay,
don't mind
that's fine.
staying, but if people want to leave, we understand.
No.
So, questions?
Yeah, I just have one for Judge Deal, which is you indicated there's not much benefit to the post-petition educational program. In the Northern District of Georgia, do the trustees provide that?
One of our trustees does, not the trustee that's actually in my court.
For Mr. Rivera, one of the things you proposed was eliminating the debt limit altogether in Chapter 13.
Yes, sir.
To prevent the perfect getting in the way of the good, if there were a debt limit, what would you propose?
It's a complicated question because you also have to figure out what the index should be, because I suspect that the limit was probably appropriate, the current limit was probably appropriate when it was set, but that the index hasn't kept up.
Not to put you on the spot now, but it's part of putting your paper, as putting whatever writings you submit together.
Okay.
Can you address that?
I will. I think it would have to be a big number, and at most, I read in one of the judge's submissions prior that, at least in her court, what she's seeing is that student loan debt, and this was a real case, I think, was over $500,000. And so, that's a big, really big number. And once you go that big, I think you might as well just get rid of the limit altogether.
If there were a limit, would you agree with some of the prior panelists that there should there be a difference in unsecured or secured, or eliminate that distinction, in your view? Have you thought about that?
I have not, and I would be curious to know why the drafters of the limit made a distinction. Real estate in Southwest Florida is not quite as expensive as it might be, say, in the valley here, but it's pretty expensive. And maybe $1 million home is a really nice home, but a $350,000 or $450,000 home is nothing significant. In my written submission, I also have concerns regarding, I don't see a distinction between the mom and pop business owners that own an ice cream shop and the mom and pop. We see it a lot in my district where they own rental properties. And so they're going to be in excess, they own 3 or 4 or 5 or 6 $500,000 homes. And they're going to be over almost whatever limit. And they're not making a lot of money. It's not a complicated business. They're renting these things out for $800 or $1,000 a month. I don't think they should be pushed into Chapter 11. I think the no-look fee in our district is $4,500. These individual Chapter 11 cases that I participated in the late 2000s, I want to say the minimum fee was something like $35,000. And these people are no different. They're individuals. They're small business owners. I think they belong in Chapter 13. And from a creditor's perspective also, I want them under the supervision of the Chapter 13 trustee. I share in the comments of the prior panelists.
May I ask a follow-up with regard to that? If you were to eliminate, as you originally proposed, the Chapter 13 limits entirely, wouldn't you be including a lot of very large sole proprietorships that maybe aren't mom and pop, unless you're defining mom and pop as quite significantly? And wouldn't that lead to issues with regard to what's proper reporting, business reporting versus consumer reporting?
So I think your point is very well taken, and I'll consider it in my written submission and address it. At least in my district, we don't see that. Our individual Chapter 11s are all, these sorts of they're mom and pop businesses. They're just much larger mom and pop businesses than might have existed, when the limits were adopted. So I personally haven't experienced that issue. But your point's well taken.
Why don't we take a 5-minute break? And thank you very much for your
Thank you.
comments.
Thank you very much.
Oh, thank you.